Hello, everyone. Thank you for joining the Whitkin State Law Library, part of the California State Library, for a special program on revenge reform, the campaign to weaken public health emergency powers with Dr. Michelle Mello of Stanford University. My name is Elena Smith, and I'm the host of today's event. I'm a reference and outreach librarian in the Whitkin State Law Library of the California State Library. We also have two co-hosts today, Mona Robinson, who is a supervising librarian for our law and government publications sections, and Kimberly Sims, one of my fellow reference librarians in law. Mona will be monitoring our Q&A section throughout the talk for any questions you may have for Dr. Mello, and she will read your questions during our Q&A session at the end of the presentation. This program would not be possible without the support of the California State Library Foundation, for which we are eternally grateful. To learn more about the foundation, you can visit their website at cslfdn.org. Before I go any farther into our program introduction, I also want to acknowledge that I work on the unceded ancestral homeland of the Nisenan and Miwok peoples, many of whom continue to live and work here today. As such, I'm a guest on this land, and I want to acknowledge, thank, and honor my hosts. The California State Library is thrilled to have Dr. Michelle Mello of Stanford University here to explore the recent legal challenges surrounding public health emergency powers, the concerns that motivated these changes, and the potential consequences for combating future pandemics. It promises to be an exciting and interesting talk. To make sure you have the best experience possible, I'm going to go over a few technical housekeeping details, and then we'll get into the presentation. If you have any questions during the presentation, please type them into the Q&A section, and we will answer them at the end of the program during our Q&A session. This presentation will be recorded and made available after the talk. Just give us a few days. The live transcription is enabled, so if you'd like to see captions, click the CC icon to show subtitles. If you run into any technical difficulties during the presentation, please put those in the Q&A section, and we will try to help you if we can. Please also note that the library provides these webinars for informational purposes. Speaker opinions and viewpoints are their own. We've added links related to the California State Library and Dr. Mello in the chat window. As a companion to this event, the Law Library is developing a research guide highlighting our many public health legal resources. We hope to email a PDF version of it and its two companion guides to you when we send out the webinar recording. For any state employees without a library card, please consider applying for one through the posted online application link, and don't forget to register for one of the state library's many other speaker programs. Okay, and now that the housekeeping is out of the way, let's get to the main event. Dr. Michelle Mello, professor of law at Stanford Law School and professor of health policy at Stanford University School of Medicine, conducts empirical research into issues at the intersection of law, ethics, and health policy. She is the author of more than 260 articles on medical liability, public health law, pharmaceuticals and vaccines, and ethical and legal issues pertaining to biomedical research, data use, and artificial intelligence, among other topics. The recipient of a number of awards for her research, she was elected to the National Academy of Medicine at age 40. Dr. Mello holds a JD from Yale Law School and a PhD in Health Policy and Administration from the University of North Carolina at Chapel Hill. Please join me in welcoming Dr. Michelle Mello.
Thank you very much. It's my pleasure to be with you here today, especially on a day when I'm trying very hard to stay offline until after bedtime. So if I can help the polity by providing an hour of alternate entertainment today, I will consider this time well spent. But I'm also really excited to share with you some of the research that I've been doing on the lasting legacy of the COVID-19 pandemic. I'm a health lawyer. I'm really interested in thinking about the role of the law in improving population health. And this has been an important time for reflection as we begin to digest the lessons from the pandemic for medicine, for public health control. There are also lessons for law and lawmaking. And so I've been engaged for the last couple of years in a project to try to understand some of those lessons. to take us from today, a time where there is much unrest and anxiety, back a couple years to another time where there was much unrest and anxiety, let me just bring you back into mind about what it was like at this point in the early stages of the COVID-19 pandemic. After the first few months, really just 2, 3 months, the leadership response, it was becoming clear, was going to be rather anemic at the federal level and very fragmented at the state level, with governors making very different decisions about the direction that they would like to go in. As you probably recall, around early June, the initial stay-at-home orders that everybody imposed and honestly people complied with to a very large extent without complaint, began to be lifted in some states and maintained in other states. And we began to see very different trajectories for a pandemic response. At the same time, and not unrelated to that, political polarization around the pandemic became much more evident. We began to see a red-blue divide in terms of how individual Americans thought about the pandemic and the pandemic response and what was required. This polarization, in my opinion, was very much fanned by some political leaders, state, local, and federal, and also by media on both sides of the political spectrum, as well as currents on social media. But it also, I think, reflected some core disagreements about the fundamentally important values that we share, but that we prize to different degrees, with some Americans really emerging under the banner of health freedom and autonomy, and others talking more about values like safety, solidarity, community, and so forth. There was, as I've said, a declining tolerance for stay-at-home orders and other restrictions imposed for the pandemic, even in areas where there was not a lot of disagreement that they needed to be maintained. Americans were beginning to grow very weary and very worried about the economic and educational effects of those lockdowns. And there was also, even in blue states, a growing sense that there were rather anemic ways that one could hold health officials accountable for the decisions that they were making and seemed to be making with very little involvement from Democratic branches of government. So across the nation, we kind of saw this fraying of a long-held understanding that when infectious disease is on the line, and therefore what I do affects what happens to my neighbor, I'm willing to trade off a large share of liberty, with only some Americans hewing to that, and others beginning to express their opposition, as you'll recall, in very strident and even violent terms, such as this picture from a school board meeting captures. So we get this backlash emerging pretty early on in the pandemic, and it persists and deepens and broadens. And by 2022, it has become apparent that individuals' faith and trust in leadership has taken a profound hit. So these data that were collected by Jillian Stillfisher and her team in February of 2022 show that only 37% of Americans at this time said that they trusted the CDC a great deal to give them health information that they could trust. And similarly, trust in state and local officials was around about the 1/4 mark for a great deal of trust. Trust in elected officials, state, local, as sources of health information was even lower, only about 10%. And these numbers are much depressed when we compare them to similar polling that was taking place a decade ago. So there really was a big hit in public trust for traditional sources of leadership and information in public health, and other data from this same poll really connected that in large part to a perceived lack of accountability for really burdensome health orders. So this really created a situation that sowed the seeds of what I'm going to call today revenge reform, which are efforts by legislatures and judicial challengers, lawsuits, to pull back or retrench some of the emergency powers that had long been reposed in state and local health officials. I think the motives behind this are manifold and not the same everywhere across the US, but certainly there was a desire among some state legislators to try to vindicate the public's anger and sense of having been wronged by unaccountable health officials. There was a desire in some quarters to go farther and to punish those who had caused hardship for others and retake control over the pandemic response from, again, health officials that were viewed as unelected and unaccountable. The law plays actually quite an important role in mediating this kind of public backlash to traumatic national events. Atul Gawande, who has written about the advent of medical liability in China, talks about the law as civilizing the passions. He was specifically talking about a situation in which, because families of injured patients had no means of obtaining redress in the legal system, you couldn't sue for medical malpractice. What they would do is instead beat up their doctors. They would literally take the law into their own hands. And however flawed the legal avenue for redress that was created, Gawande's argument is that this does provide an outlet for impulses that would otherwise take a violent turn. And that's not to say that in the US they didn't take a violent turn, but there is a way of thinking about legal reform as sort of having instrumental value in containing and providing an outlet for people who have anger and are looking for a means of voice. So I think it's useful to kind of understand it in that way, that it is not only punitive, but also a desire to have voice in the political process. But to many health officials, certainly this felt like a kind of revenge initiative to try to get them back for having imposed orders that people disagreed with and felt they had been hurt by. I titled my talk "The Campaign to Undertake Revenge Reform" because it was organized. It was organized and spearheaded by an organization called ALEC, and as I'll talk about in just a minute. And what I was interested in doing is looking at the outcomes of this initiative in terms of the long-term impact of public health lawmaking outside the COVID pandemic. So this project was funded by the Commonwealth Fund. Part of the project involved looking at ways in which the pandemic suggested our public health legal infrastructure might need to be modernized. I'm not going to talk about that part of the project in my presentation today, but I'm happy to talk about it in Q&A. I think there were some important lessons about things we could do better with public health emergency powers laws. The part I want to talk about today is instead these retrenchment efforts, both in state legislatures and in the courts, to try to claw back some of these powers. And again, these were spearheaded by an advocacy organization called ALEC. So turning first to the legislative retrenchment study, in this study, colleagues at Temple University and I looked at, across the United States, at efforts in the wake of the early days of the pandemic to try to pass legislation to curtail public health powers. There were hundreds and hundreds of these bills, and we focused on those that became law. A lot of these laws were modeled after model legislation that was proposed by this right-leaning advocacy organization called ALEC. And I'll just share the model act that this organization had suggested that state legislatures consider. The laws that I'm going to talk about don't look exactly like this, but they were clearly strongly influenced by this model legislation. So in this Emergency Power Limitation Act, the organization suggests, for example, that health orders should only be possible legally if they are narrowly tailored to serve a compelling public health or safety purpose. Now, that's language that comes from constitutional law cases in which challengers are alleging that a fundamental constitutional right, like religious liberty, has been infringed. That standard requires courts to look very, very hard at the legislation and only to uphold it if it serves a compelling interest, as we see here in this language, that cannot be accomplished through any other means, essentially. That's what we mean by narrowly tailored. The standard is known as strict scrutiny, and it is almost always fatal to the order, almost impossible to satisfy. Elsewhere in this Emergency Powers Act, we see the suggestion that only a governor be allowed to issue emergency orders, not local health officials, and that all orders will automatically expire after a week unless the legislature convenes and ratifies them. So the executive branch's function in pandemic management ends after a week. And there is no additional management unless the legislature can get together and agree on how to manage it. The other interesting provision associated with this is that the governor is prevented from reissuing any emergency orders. This is picking up on the fact that in a lot of existing emergency powers laws, there were time limits on orders, but governors could renew them almost as many times as they would like in most states without having to make any specific showing. So those limits were, as a practical matter, pretty hollow. This is aiming to prevent it and essentially, again, shifting the balance of power in pandemic response from governors, from the executive branch, health agencies, to legislatures. So again, this is just a proposed act, but this organization had a lot of influence. And when we look at what was actually passed, we see reflections of this language in a lot of these, what I call retrenchment laws at the state level. So let me talk about what I found. What we set out to do was identify bills that had become law at the state level that restricted public health emergency powers in some way. And we're particularly interested in those that restrict powers to issue what I'll call community mitigation measures, things like vaccination mandates, stay-at-home orders, school and business closures, gatherings restrictions, and so forth. And we were interested in laws where the impact of the restriction would outlast the COVID-19 pandemic. There are lots of laws on the books, actually, that were specific to COVID-19 or the COVID-19 period. For example, they restricted the ability to impose a vaccination mandate for COVID vaccines. We chose to focus on those that would have a more lasting impact. And our goal was to try to understand, by interpreting the content of the laws, what kind of impact they might have. So to do this, we followed methods of legal epidemiology to systematically identify these laws, and then to abstract key elements of the laws into a structured coding instrument and do some thematic content analysis. So what did we find? There were 65 laws adopted in 24 states that restrict emergency powers beyond the COVID-19 pandemic. And just let that sink in for a moment. Almost half the states took steps to claw back some of these powers. And they were not just red states, although there was certainly a correlation between leaning right and adopting some of these laws. We separated our laws into two general categories. In the first categories were laws that imposed some kind of substantive restriction on what health officials and elected officials could do to try to deal with health emergencies. So, for example, restricting their power to institute a particular community mitigation measures like closing businesses. And in the second were laws that were procedural tweaks in the amount of time that an elected official could impose a health order for, or the process for extending or terminating or challenging a health order or an emergency declaration. So let me unpack each of those categories a little bit more, starting with the substantive restrictions. This chart summarizes the specific kinds of substantive restrictions that we identified. And you can see they're really broad and diverse, but they concentrate in a few areas. One has to do with vaccination requirements of various kinds. So for example, 4 states adopted new prohibitions on requiring vaccinations or proof of vaccination, and 4 expanded the required exemptions to vaccination requirements. For example, now requiring as a matter of law that a religious exemption process be in place that was not previously understood to be required as a matter of constitutional law. Other states focused on the idea that we don't want to be closing schools and businesses, or at least with the degree of discretion that was done during the COVID pandemic. So 7 restricted the ability to close businesses, 4 restricted the ability to close schools. Just to take an example of that, in Ohio, whereas they used to be able to close schools for such time as they felt was necessary to deal with a disease outbreak, going forward, they will be restricted to closing specific buildings within a school where a case was present, and then only for such time as it takes to disinfect the building. So this essentially means no school closures as a preemptive or preventive or disease spread arresting measure. 6 states either barred completely or limited mask mandates. And 11 restricted state or local officials' authority to limit religious gatherings or otherwise restrict the activities of religious organizations. Very common there was adopting Alex's suggested language of the strict scrutiny rule that it could only be sustained if it could be shown to satisfy a compelling state interest and be the most narrowly tailored measure possible that would advance that interest, which again can essentially never be satisfied. And some went so far as to adopt what's been called the most favored nation rule of a Supreme Court case called Tandon. And this rule is essentially that a state cannot restrict religious activities more than secular activities that judges deem to be comparably risky. So not what the public health officials deemed to be at comparable levels of risk, but what a judge thinks is risky. So another way of saying this is that if a judge finds that shopping at grocery stores or hardware stores is as risky as going to church, you may not shut churches down unless you also shut down grocery stores and hardware stores. 11 states adopted preemption provisions. Preemption provisions deal with situations where local and state law, or sometimes state and federal law, is in conflict with each other. It's a rule about which one is going to control. And in all of these situations, the rule that was adopted by the state is that whatever is more lenient in terms of disease control is going to be the prevailing rule. And finally, 3 states adopted language that, in effect, bars any kind of health order that affects a whole class of persons. This would encompass stay-at-home orders, quarantine orders of uninfected individuals or individuals who have not been demonstrated to be infected, or other things that apply to groups as opposed to specific enumerated individuals. So again, this is a broad range of different measures. It focuses on things like vaccination, mask wearing, and religious gatherings. And it truly does impose some significant limits on the tools that will be in the public health disease control toolkit going forward. The other kind of measure that we saw are these procedural laws that have to do with shifting the balance of power between the executive branch, governors, county officials and health officials, and the legislative branch of government. So these reforms often tighten time limits on emergency declarations or individual health orders that are issued pursuant to declarations, or alter the process by which those orders can be extended in time or terminated or challenged in court. So, for example, several states provide now that the legislature can terminate a governor's emergency declaration at any time instead of after 90 days or something like that. Or they restrict the ability of a health official as opposed to a legislature to issue particular kinds of orders. Some of these laws involve legislatures to such an extent that they may truly compromise an effective emergency response. For example, there is a Florida law now under which local health officials lose control over emergency response after 7 days. At that point, it becomes the job of the legislature to run the response, and individual health officials can't act on their own. So, what should we make of these laws as a group? I think maybe the sunny side of things is that, first of all, you might say that legislatures overall showed a lot of restraint in that about 2/3 of the laws that we screened that do restrict public health emergency powers don't apply beyond COVID-19. So at least they were restricting powers in the context of a pathogen they knew or felt that they knew, that they had some familiarity with, and are not binding the hands of health officials dealing with the next pathogen X that might be much more dangerous than COVID. A second sort of bright side is that some of these measures, while they might make it more cumbersome to manage emergencies, don't make it impossible. There's still a lot that can be done. It's just that the processes are going to be a little bit more involved. There's going to be more need for legislative involvement, for example. And I do think that some of the procedural reforms could actually be helpful. I think it's not unreasonable, for example, to have laws that require executive officials to make certain showings that we might say in the law, to explain to people the scientific basis for the orders that they're entering. It's an important and demonstrated measure for building public health support, trust in the legitimacy of what is going on in government, and that can help ensure that people comply with the orders. And finally, some existing laws, as I've alluded to before, really had no meaningful time limits. They allowed governors to re-up these emergency declarations and health orders without limit and without involving any democratically elected branch of government. And, I think arguably it was time for a reset on that balance of power. At a certain point in a multi-year pandemic, it does, in my view, become appropriate for democratic branches of government to have a bigger role as we begin to make important decisions that balance public health against other values, like educational continuity or economic health. So I think these are all nods that we can give to this retrenchment movement in the direction of, well, perhaps it's not that bad. I do think, though, there are some pretty dark points to be made about what has gone on here as well. And one of them has to do with health equity. I've said already that these laws tend to track with more red-leaning states. Unfortunately, those are also states that systematically underinvest in public health, every day. So where there are already states where individuals generally have a lower degree of public health protection from all kinds of major health threats. And what these new laws sort of do is exacerbate that two-track public health system by now undercutting the degree of protection that they can expect during emergency periods. Second, I do think it's quite dangerous to completely take out of the toolkit things like stay-at-home or mass quarantine orders. Nobody wants to have to use those, but surely there will be another instance in which we want to have the option, at least on a short-term basis. It seems to me quite short-sighted as well to significantly restrict vaccination or mask-wearing requirements without knowing what kind of pathogen you might be dealing with. Emergency health powers laws are deliberately broad so that individual officials can have the discretion and flexibility that they need to manage emergencies, which, by their definition, are very hard to predict what's going to be needed. So this kind of substantive restrictions on what can be done strike me as really quite dangerous. And then lastly, I have concerns about whether legislatures will be able to rise to the occasion here and perform the jobs that they've given themselves here. For a legislature, for example, to assume control over a pandemic response a week in, when we think about how hard state and local health officials worked during COVID, working around the clock, having to make decisions very nimbly without a lot of support, it's hard to imagine a legislature performing that same work in the same way as effectively. And so again, I think there's the possibility that we get greater inaction in the face of future pandemics. So let me now shift gears and talk about the second component of my work. I've talked already about what state legislatures have done to try to claw back some emergency powers. Of course, another major force for curtailing public health powers and seeking revenge on public health officials during COVID was litigation. And so the second thing we set out to do was try to understand what has gone on in these lawsuits that have been filed by individuals who are challenging community mitigation orders. Other work had already demonstrated that the government usually prevailed in these suits. About 2/3 of the time or so, if not more, the government would ultimately win the suits. But we were curious about what happened in the other suits. So with Wendy Parmet at Northeastern Law School and my student David Zhang, we undertook to examine the cases where plaintiffs won. Specifically, we sought to examine decisions that might have lasting effects on public health emergency management or even everyday public health activities going forward. And to do this, we screened for any case that had a decision between March 2020 and March 2023 that was not overruled, where the plaintiff had prevailed on at least one claim in a challenge to a community mitigation order during COVID. And those orders included vaccination mandates or certification requirements, mask wearing requirements, orders closing or restricting business operations or schools, and orders restricting movement like travel or gatherings, including religious gatherings. We abstracted key aspects of these decisions into a structured database and conducted some thematic analysis and quantitative analysis of what we found. And we identified 112 judicial decisions that met these inclusion criteria. I want to share with you a little bit about these plaintiff wins. So first, where we look at where they came from, 9 of these are U.S. Supreme Court decisions, but most of them took place in federal district courts. These are trial courts in the federal system. There were also, however, some important state Supreme Court and lower court decisions as well. And then on the right-hand side here, when we looked at the type of health order that was being challenged, you can see that the most numerous type of claim in which plaintiffs prevailed were challenges to restrictions on gatherings that were not specific to religious organizations, but rather were general. Restrictions that targeted religious organizations were also very numerous in this sample. And finally, vaccination mandates and certification requirements, very numerous among these plaintiff wins. And you can see there's a smattering of other kinds of claims as well, including quite a few claims relating to mask mandates. We also examined the legal claims that these challengers had brought. What we see here is that 2 kinds of legal claims predominated in these cases where plaintiffs won. The first was a challenge alleging a violation of religious liberty or free exercise of religion under the First Amendment. And the second were challenges that said that some state or local official exceeded the authority that had been given to them by a statute, by an act of the legislature. For example, a state health official entered an order that she wasn't allowed to enter, that only the legislature should have been allowed to enter. There were also quite a number of claims alleging equal protection, that 2 groups of people were treated differently, for example, hardware stores and churches. Alleged procedural due process violations, saying that you deprived me of liberty or a property interest without fair procedures, or substantive due process restrictions, which is essentially a constitutional claim saying that there's a zone of protected liberty into which the government impermissibly intruded. And then again, there were a smattering of other kinds of claims, such as claims that the government essentially took private property without fair compensation, or that a legislature had delegated authority to an agency in a constitutionally impermissible manner. That's called a non-delegation claim. So let me share some of the major findings of our review of all these claims. One really important finding is that heretofore, it seems clear that even health orders of broad applicability are going to be struck down in a number of cases if they burden religious activity. Now, under the pre-pandemic state of the law, courts would have considered these kinds of health orders to be so-called neutral laws of general applicability. And what that meant was that courts would apply a relatively light level of judicial review, known as rational basis review. When instead these laws are recharacterized as something that targets religious activity, the level of review gets amped up to that strict scrutiny threshold, which is almost always fatal. And again, this strict scrutiny analysis seems to have become even stricter than before with this most favored nation type analysis, saying if you treat any comparably risky secular activity better than you treat religious activity, the whole scheme falls. So again, this means essentially that religious activities can only be restricted if businesses and other activities that a court thinks poses the same kind of disease risk are treated just as stringently. And again, that makes it almost impossible to carve out essential businesses from restrictions on gatherings or from stay-at-home orders. Point 2 here is that the court's approach to these religious liberty claims has, I think, potential downstream implications for vaccination law more generally. So some of the things that the courts have been saying about religious freedom challenge long-held assumptions in legal academia and in judicial decisions that religious exemptions to vaccination mandates are not a constitutional requirement. Going forward, it seems clear from our review of a number of vaccination mandate cases where plaintiffs prevailed that if the government provides a religious exemption process, one thing that's important is that they have to do careful, individualized assessments of reasons for denials, and that many of the reasons we thought would have been sufficient won't be. So, for example, there were a number of cases involving vaccination mandates in the military, an area where courts have traditionally been very hands-off, that rejected the military's argument that a general interest in military readiness or a healthy fighting force was sufficient to require service members to accept vaccination. Rather, unless they could prove that this service member must receive the vaccination in order for military readiness to work, they could not require it. And so that makes it almost impossible to sustain a vaccination requirement, because in any military force of 100,000 fighting men and women, having one person unvaccinated, of course, doesn't cause the whole scheme to fall and the military to be unready. But if we generalize that rule, of course it does. That's the kind of logical trap that some of these cases have put vaccination mandates in. And again, then there's also this question now of whether religious exemptions are going to be a constitutional requirement going forward. There are lots of test cases now pushing that now. They're beginning to fall kind of on both sides, depending on where they're brought. And it's just really unclear at this point. And that has implications for school entry mandates as well as emergency mandates like the COVID vaccine. The third point here has to do with these challenges to agency exercises of their statutory authority. In these cases that we examined, courts construed the agency's authority really quite narrowly, even though the language in the statute was, in our view, quite amenable to a broader interpretation. And probably the most famous examples of these have to do with the Supreme Court's interpretations of the Public Health Services Act, and specifically the quarantine power that is given to CDC under that act. The Supreme Court chose to read that language as restricting the CDC to the specific measures enumerated in the statute, which are basically like inspection, fumigation, disinfection, and declined to read it broadly to include the power to institute, for example, a stay-at-home order or an eviction moratorium, or a cruise ship no-sail order, even though the statute refers to there's like a catch-all provision that says that the director of the CDC can also do other things that they deem necessary. And this was all before the Supreme Court's decision in Loper-Bright last summer, which further curtails federal agencies' discretion to interpret their own statutory authority. What we also saw in some of these cases was courts invoking a newly invented judicial doctrine that dates just to a couple of years ago in a case involving the EPA called the Major Questions Doctrine, in which the Supreme Court said that if Congress would like agencies to do things that involve major questions of political or social or economic significance, it must say so with exquisite clarity. There can be no room for doubt. And almost anything, it seems to this court, fits that description. So, for example, in a case challenging the CDC's restriction requiring people to wear masks on public transit, the court invokes this doctrine and says, whether you wear a mask on a bus is a question of vast social, economic, or political significance, and therefore CDC cannot require this unless Congress specifically says so. So this is a major restriction on CDC's ability to do things that it deems necessary, but that are somewhat novel in pandemic response. And it's a restriction that floats over to other agencies like CMS as well. So over the long term, there's a clear need for Congress to clarify what powers it intends these agencies to have. Unfortunately, the prospects for doing that in the current political environment are extremely low. The next point that I want to make has to do with rulemaking procedures. Some of these cases create a basis for plaintiffs to argue that health orders are formal rules. And that matters because when something is a formal rule issued by an administrative agency, it has to hew to certain promulgation procedures described in State Administrative Procedures Act, or if we're talking about the federal government, the federal APA. And in particular, it generally has to go through a notice and comment period, which can be a very lengthy process, very arduous, and which a more recent Supreme Court decision clarified that if you do not do it really, really well, if you do not respond to each and every comment satisfactorily, your whole rule can fall later on. And so this is a pretty big reclassification of something that we previously thought was an order as a rule. And when one begins to imagine the implications of having to do notice and comment in order to issue rules for managing a health emergency, it gets pretty scary pretty fast. Now, there's a good cause exception to that rule. If you can show that you just can't go through notice and comment right now, the courts will sort of give you a break. But it's quite clear from these cases that that break ends after a couple of months into the emergency. Courts are going to lose their patience with that excuse. So our advice really is to, obviously sometimes emergency orders are going to have to be issued on an emergency cause basis, but health officials ought to be thinking and planning for moving to rulemaking very swiftly if it looks like this is not going to be a short-term emergency. The final thing that we noticed in these judicial decisions was courts really fixating on the fact that officials often issued health orders without explaining why. What was the basis? What was the evidence? And to be quite honest, I think they have a point. There were a lot of instances where the basis for the orders was not explained and where the orders were not timely revisited as knowledge about COVID and COVID transmission grew. And litigants often ask very good questions like, do church services in fact involve more risk than retail shopping? Or why is a 6-foot social distance necessary for elementary students, but 3 is okay for middle school students? Such questions often have good answers, but when officials don't give them, it again undermines trust and a sense of legitimacy around rulemaking. And so if one thing that may come out of these decisions that's, I think, positive is encouragement for officials to articulate the evidentiary basis for the order and be diligent about revisiting that basis when conditions change. So to sum up, we found in this work that in over 100 cases, the courts here disrupted really long-held assumptions about the scope of public health powers. And the willingness of courts to do this, to intervene, including the Supreme Court 9 times during the pandemic, I think has really reinforced and invigorated litigation as a strategy for challenging burdensome health orders. And more generally as a resistant strategy to the enterprise of public health, which often does involve restrictions on liberty or property rights. So officials really do need to, I think, understand this new reality, to anticipate it, and to do policymaking in a way that responds to it and plans for what I think are a fairly inevitable set of legal challenges going forward. So I'm going to pause there and take some questions. I do want to note that both of the articles that I talked about are available with free access through these links and will also be, again, published on the website from today's event. Also, for those of you who are involved in teaching activities, I do have a little module that I've prepared to help students and including professional learners understand this new landscape, which you're very welcome to have as well. Thank you very much, and I'd be happy to take questions.
Thank you, Dr. Mello, for that engaging talk. Now we'll open it up for questions. If you have any questions for Dr. Mello, please type them into the Q&A box. Mona, did we have any questions that came in during Dr. Mello's talk?
Yes, thank you so much. Thank you, Dr. Mello. It's such a complex and knotty problem, and I think we have some questions for you. The first question is, what consequences do these new laws restricting public health measures have for the division of powers between federal and local governments?
So, states are obviously restricted in their ability to rebalance that power. The Constitution sets out a certain schema, and states don't have a whole lot of wiggle room to adjust the schema. But I will mention one very weird thing that we found in some of the laws, which is that in a few states, the legislature has said that their officials may not enforce federal health orders that their own attorney general has deemed unconstitutional, regardless of whether any court has deemed it unconstitutional. So that is, again, like almost without precedent. and very, very odd in terms of our federalist scheme. We don't generally give state and local officials the ability to opt out of federal law of any kind. And yet, a number of states have asserted the right essentially to overrule federal decisions about emergency management. But beyond that, I think the main thing that has challenged the division of state and federal power is not the state laws, it's some of these judicial decisions that have made it so much more difficult for federal agencies to do things that aren't prescribed explicitly in statutes. And the effect that that will have on federalism is that when we know the CDC cannot do something, the pressure will be on state and local officials to do that thing if it is important to them. For example, an eviction moratorium is not going to be a federal thing going forward. If you want to have an eviction moratorium, that will most likely need to be local.
Great. Thank you so much for your answer. Okay, so next question. Is there any data on the increase in mortality or illness resulting from recent court restrictions on measures that public health agencies attempted to implement? That's a great question.
That is a great question. Yeah, so I'm not aware of such studies, and the challenge would be around the timing. These were really pretty recent court decisions, and many of them would have been handed down relatively late in the pandemic, by which time mortality had already dropped. So it's hard to causally attribute the observed mortality differences between, to generalize a little bit and oversimplify a little bit, between red and blue states to specific judicial decisions. More generally, we know that when judicial decisions come down that have direct impacts on people's access to care, people's degree of public health protection, they do tend to matter. But this one is a little bit slippery to document just yet.
Okay, great. Thank you. Thank you for that answer. Okay, next question. They're curious if they saw the lack of alignment between government and health officials influence the lack of trust in health officials. I feel like this is a really good question too.
The lack of alignment, did you say the lack of alignment between government and health officials?
Yeah, like it does seem like this legislation, these judicial decisions are affecting how the public views health officials. Sometimes they are villainized, sometimes,
I see. So thinking about elected officials versus health officials. Yeah. So, I mean, even apart from the issue of like, what is the legislature doing and how much is that undermining what the health officials trying to do? We've certainly all heard of cases where governors and county chief executives have been openly undermining what their own health officials have been trying to do. And that's incredibly difficult. It's difficult in terms of fostering compliance with health orders because the legitimacy of it has openly been questioned by the chief executive. And it's difficult in terms of emboldening health officials to do things that they think are necessary because it often comes at enormous personal cost to them when they're not supported openly and strongly by the chief executive. So I think there's a legal question about, when the legislature does stuff to restrict powers, how does that hamstring public health officials? And that's what I looked at in my work. But there's this very interesting separate question about kind of the atmospherics of political division within states and what that does to public health officials who are already hanging on by their fingernails. And, I'm less familiar with evidence about, when the political environment deteriorates, do these health officials act less boldly? But certainly there's enough studies now of the, for lack of a better word, suffering of the local public health workforce to suggest that there's a strong correlation between not feeling supported by those executives and either leaving entirely or simply trying to throttling back the response to what they think that they can sustain in the face of that political opposition.
Thank you. That's a great answer. And I'm wondering from the public's point of view, it's just so frustrating for the public who relies on the health officials and their legislators to just do the right thing. So other than voting, what kind of stance can the public make? This is just one of my questions personally.
Well, it's a great question. And one of the problems, I think, is that there have been kind of limited opportunities for the public to have voice over these matters, either in opposition or in support of health officials. When we cast our minds back maybe to our own communities during the pandemic, maybe we remember that the main avenue through which this occurred was these kind of town hall meetings or school board meetings that were just festivals of vituperation, of screaming at each other. And so whether you are against or for the public health orders, in my opinion, these are not the best ways for the public to contribute input. It's not a forum that invites sort of cool-tempered evaluation value balancing. It's a forum that definitely brings out the passions. So I do think it's really valuable to think going forward about other ways in which people can express support for or opposition to health orders that are more constructive, that avoid kind of letting us whip each other up into an angry and very hot state that just compounds the pressure on health officials rather than providing them with information that will be helpful for them as they try to balance their mission of health protection against other values that are clearly important to the public.
Great. Thank you so much for answering my question. Okay, so let me move on. Is there any correlation between states that have invested in COVID communications campaigns, taking COVID as an example, and states that had more court restrictions on measures? Curious if communication investment buttresses health officials' actions.
Well, it's a great question. I mean, there's certainly a very strong gestalt in the academic community around the importance of communication as a mechanism for building buy-in, especially among minoritized communities and others who might otherwise be kind of naturally inclined to distrust government, as opposed to the bulk of Americans who, until recently, were pretty inclined to trust institutions. But harder evidence than that is it can be a little bit hard to come by. But the bottom line is, I don't think anybody would argue, oh, next time we need to communicate less and worse. There was clearly major failures in communication, some of which, just have to do with the frequency or quality of communication, and some of which are much more fundamental and have to do with who is communicating. Are they the right messenger to reach particular kinds of communities? And then how did we handle the fact that part of science is that things change, knowledge changes, and we have to change course? Because that was a major problem in the COVID communications, that people felt like when advice was changed, for example, around mask wearing, that was a reason to distrust the messenger. When I would argue as a scientist, it's the reverse. When somebody's willing to acknowledge that initial advice was incorrect because more has been learned, that's science working the way it should. But we've reached a state where that kind of message is extremely hard to deliver. So I think it's right that there's a lot of focus now on trying to improve communication skills for health officials, federal, state, and local, going forward.
Thank you so much. Also, there's some questions, a couple questions about concern about diseases that have already been, like tuberculosis and polio, that have already been vanquished and now are threatened again, in some people's view, by the possibility of even stricter anti-vaccination federally. Government action. So I'm wondering, do you have any thoughts about how this could morph over to that?
Yeah, I do. I mean, there's been evidence already, as many on the call probably know, that childhood vaccinations have seen a dip since COVID, and it's very much correlated with people's broader views about the safety of vaccines, which are correlated with their political views. My high schooler came home for the very first time with a notice about a pertussis exposure 2 weeks ago, and that shocked me. Yeah, it really, really shocked me. That is the world that we are now re-entering, where some of these childhood diseases now are in danger of breaking through because places where we had herd immunity for the most infectious diseases have now dipped enough into a place where we no longer have that. So that's a scary outcome. without getting too partisan, the possibility that we might have a Secretary of Health and Human Services that's an open vaccine safety denier obviously has some implications for the direction that things are going to head in terms of that. And, I think where we have landed in terms of that is like that if it doesn't come from pediatricians, it won't be trusted. And even the pediatricians are struggling with higher than ever levels of distrust in them. But they're kind of the last line of defense, I feel, for reinvigorating confidence in vaccines, because all of the other messengers, as you sort of reflect back on that graph that I showed with the colors, our more traditional messengers of state, local, and federal public health officials are just not broadly enough trusted anymore to overcome the kind of misinformation that is driving anti-vaccine sentiment.
Oh, that's great. And that's a great point about pediatricians. I mean, maybe they'll be the ones that, can at least stem the tide from taking this too far at this point. And so we only have time for one more question, and I see that there's a few more questions here for Dr. Mello. Also, apologize for the chat window, and I promise you that we will send all the links for Dr. Mello's information when we send the link recording out. And we're also going to send the research guide. So don't worry, you'll receive all that information even if you cannot copy it from the chat window. Okay, Dr. Mello, there's a couple questions about the election that we're not going to go with, but I understand why they're there. And just how about this one for our final question? Has there been any recent litigation to reverse the diminished powers of public health officials? Are there any possible remedies in this vein? Like, this is a kind of a hopeful sounding question. So, do you see any light on the horizon? Is there any current pending litigation that you think could help?
Yeah, that's such an interesting question. The problem that we generally have is that all of our constitutional rights are framed as non-interference rights. So they're rights that protect us from government interference into certain kind of protected zones. There's very little in the Constitution that creates a basis for requiring government to do more of anything, and in particular of furnishing more services. So as a constitutional matter, the prospects aren't great. That the few times that people have tried to argue that as a matter of constitutional right, they're entitled to more of something from the government, it just has not worked out. Where there's maybe more latitude is around enforcement of statutes that provide access to healthcare and other services, like the Affordable Care Act, like Medicaid and EPSDT Acts. Those provide causes of action for people to go to court and at least make the argument that access to healthcare is insufficient. But it's pretty limited in the public health space. For example, I wouldn't have the right to go to court really and argue that my child should enjoy more protection from pertussis in the public schools, because that is, a matter of constitutional rights. As I reflect, there may be some state constitutional provisions that frame rights to health or health care a little bit more broadly and that could potentially provide vehicles. I don't think we have any such statutes here in California or constitutional provisions here in California that would be useful, but that might be one avenue, but it's generally pretty tough to do.
Okay, well, thank you for that. And I believe that's all the time we have right now. I know that there's a few questions on that have been left unanswered. Perhaps, Dr. Mello, we could send them to you if you want to answer them. We can let the people,
Sure, I'm
attendees
happy.
know.
I'm easy to Google, and I'm happy to hear from people by email if they have additional questions.
Okay, great. Thank you so much. And we really appreciate your time and your attention and all the research that you've done into this really important topic. And so with that, I will pass it to Elena. And thank you again.
Thank you.
Thank you so much, Dr. Mello, for this really wonderful presentation. And thank you, Mona, for monitoring our Q&A. And thank you all for attending. If you're ever in the area, please visit the State Library in person at 914 Capitol Mall in Sacramento. We're open Monday through Friday, 9:30 to 4. Thank you all for attending and have a great day.